So we're just going to use, so 3-105, or for the CCC, it'd be 3105 without the dash, right? Issue means the first delivery of an instrument by the maker or drawer, whether to a holder or non-holder, for the purpose of giving rights on the instrument to any person. Okay? So when you, let's go back to this, right? So generating a note using a credit card makes you the representative on behalf of the sole prop, who is the issuer. So the sole prop is giving the first delivery of the brand new generated instrument. He is the maker or drawer, and he's giving that instrument to a holder or non-holder for the purpose of giving rights on the instrument to any person. Now, what those rights are and how they change depending on holder or non-holder, that's kind of a lot of where my research is right now. I don't have all the answers for that at this exact moment in time. I'm working on that currently. Very hard to find any information on that. There doesn't really seem to be any cases ever talking about it. I really can't find anything on it. So just going to keep plugging away at that. If we can't find any information on that, then we'll just pound it through the courts and we'll create all that case law ourselves from scratch, just by sheer force in the courts. Okay. So generating a note using a credit card makes the representative on behalf of the sole prop, who is the issuer. As you saw on the, start looking at your receipts, you'll see that every once in a while. Issue, note issue, or issuer. Typically it's issuer. Okay. This is how, this first option is how most people live their lives and how you've been living your life most likely up to this point, right? Point number 2, using the draft that is sent to your sole prop as a negotiable instrument, endorsing it and sending it back as a payment. You've been seeing me do this. No one's really addressed it in any meaningful way so far, but that basically is what's broken down here in this flow chart that shows the obligations and kind of how that all works. That's the CCC flow chart for Federal Complaint Round 5 Visual Aid. This was also in the First Amendment complaint on Round 3. Okay? With City of Glendale. This is one that we're continuing to use. I've never seen any court or any bar card or anybody having any meaningful conversation on this. They try to get away from this conversation as quickly as possible. That means we're onto something. That's fantastic. This is totally fine. You can just continue to pound and pound and pound. Like me, I'm just going to pound and pound and pound until we have a meaningful conversation about this, because this is a real thing. This really happens. It's all part of the commercial code. You can see the full flow chart here, all the breakdown of how everything works. And they don't want to have a conversation about it probably because they'll lose, so they don't understand it or whatever. So that's totally valid. I've been doing this for, several months, and we still haven't had a decent conversation on the subject. So we're just going to keep pounding that one until we can have a decent conversation about the subject, which will probably result in us winning. The third option is to generate a brand new promissory note, or I should say issue. Brand new promissory note without using a credit card or other banking instrument. So that's what this video is all about, right? This video is all about the brand new promissory note template, which is here on the resources and documents page. Okay, that's this here. And we're going to cover this in detail. Okay. So the way that this works is it's the same exact thing as using a credit card. When you use a credit card, you're generating a brand new unconditional promise to pay, and then the bank essentially is helping you negotiate it, transfer it, convert it, whatever. You don't need the bank's help. There's really no reason why you should need to. You can do all the same stuff that the bank is doing for you or with you by yourself, just using paper and a pen. You have to do it in accordance with the different sections, right? So first and foremost, the most important thing is you have to separate out and make sure it's clear who is the issuer and who is the representative. Okay, because I'm not the issuer of the note. The sole prop is the issuer of the note. I am the representative of the issuer. And I'll show you why that matters. So first and foremost, Article 1, Section 10 of the Constitution. Let's see if it can just give me something simple to look at so I don't have to throw myself off a bridge. Okay, good. Here we go. No state shall, and then we got all sorts of good stuff here, right? Coin money, that's an important one, right? Emit bills of credit. Interesting. I actually need to look into that one a little bit more. Now that I've seen that for the 8,000th time, for whatever reason, finally registers to me that, I should probably look at that one. Make anything but gold and silver coin a tender in payment of debts. That's the main one that I wanted to show you. Okay. So the I am not allowed as a state citizen, as a white citizen of California, I am not allowed to make anything but gold and silver coin a tender in payment of debts. It's unconstitutional. Now, will something happen to me? Is there some sort of penal code or something that will apply to me if I do something like that? No, the penal codes have nothing to do with me because Hurtado versus California has nothing to do with me. That's not my concern. The concern is just simply having a devotion to the Constitution and pledging an oath to protect it and follow it. There's really no threat behind me breaking this. If I want to break this, I guess you can call a grand jury of white Californians to come and do something to me. I suppose it opens me up for that, but we all know that's not going to happen. So people have this punishment drive mentality. Oh, what is the punishment drive that keeps Brandon in line when it comes to Article 1, Section 10 of the Constitution? Really, the truth is there isn't anything. You know, the idea that you have to have some sort of punishment drive to keep people in line, otherwise everyone will fly off the train tracks because they're all inherently evil, is a completely false, insane idea that pretty much the entire legal system operates off of. But it's patently false because back before 1860, we never had any of that shit. From 1750s, when we were colonies of Great Britain, all through the 1770s, when we became a nation, all the way through the 1860s, so for over 100 years, we didn't have any. Well, maybe when we were colonies, there was some kind of, I don't know, laws or legal system, but I don't really know. I'm not so sure about that. So let's say from 1776 until 1870, the legal tender cases, that would be almost 100 years. There was no punishment drive theory behind no state shall make anything but gold and silver coin a tender in payment of debts. It was just, that's what we did. We loved it. I just don't, the punishment drive system is not necessary and required like people think. It's this idea that everyone is inherently insane and evil. And if you don't keep the chains on all of the beasts, then they're all going to get loose and destroy everything. That's like a psychotic, that's like a symptom of the fact that psychopathic people are now in power, because that's how they think. They have this obsession with having to control everyone all the time, and they're psychotic as fuck, and they think everyone's evil. And the reason why they think everyone's evil is because, for example, the banking system is hurting everyone on the planet every single moment of every single day, creating the death of children, creating the entire human trafficking, slavery, OnlyFans, all sexual degradation, anything involving people trying to survive financially and struggling because of inflation is all created on purpose through, the banking institutions and stuff like that. And the only way they can cope with the magnitude of their crimes on humanity is by reducing the value of humanity within their own mind to an evil, horrible, degraded beast, and in order to justify their own psychotic, insane crimes. And then as they control the government more and more, they're able to sort of inject that psychotic mindset into the legal system. So as psychotic people gain more and more control over the legal systems starts thinking more and more where it's like, all right, everyone's insane and psychotic, and if we don't control them and hold them down, they're going to flip out and destroy everything. When in actuality, it's the psychopathic fucks that are doing that. People, when they're just left the fuck alone, for fuck's sake, they don't do that. They don't go crazy. They don't fuck everybody over. Do you have the occasional, it's like the Wild West. Do you have the occasional bandit? Do you have the occasional thief? Do you have the occasional, yes, you do, but it's not the whole town. It's a small percentage. And a lot of criminality that we see in today's world is actually manufactured through things like inflation and insane laws and stuff like that. It's actually, a lot of this stuff, I believe, as I go deeper and deeper and deeper into all this information, what we're really dealing with in its most basic sense is we're dealing with this like shadow war essentially against Christians and white people. That's actually, at this point in my research, as of fairly recently, that's kind of where I think a lot of this kind of stems from. It's this like internal, totally unlocatable attacks of like changing the source code of our laws and stuff like that, and in order to like destroy us in a way where we don't even ever spot the enemy to even make an attack. It's that clever and that insidious. I think that's kind of a lot of what this stuff is at this point. With that said, I don't know why I went off on a long tangent. With that said, no state shall make anything but gold and silver coin a tender in payment of debt. So when they send me a bill for my utilities and they want Federal Reserve notes and all this other stuff, I can't pay it. It's physically impossible. If I pay, I'll say, if I paid it, I'd get in trouble. If I paid it, well, no, because there's no penal code that would apply to me. The truth is, if I paid it, I'd be opening myself up to a grand jury indictment if a grand jury decided it was that much of an egregious issue, right? But the real basic fact is that if I use my sole proprietorship, then everything is legal. I'm not the one who ever paid. I'm just the representative. I legally have no responsibility over the instrument, which is straight in the commercial code. We're going to cover that in a second. And they're getting paid in what they want. So the sole proprietorship is used as like a portal or like an intermediary or like a transfer. So by doing it this way, by making yourself the representative of the issuer, everything becomes very, very legal, and it also frees you to not have to worry about the instrument. So people are like, bad checks and stuff like that. Well, bad checks, it's impossible to prosecute the representative for a bad check. You can see here in 3-402, signature by representative, subsection B, if a representative signs the name of the representative to an instrument and the signature is an authorized signature of the represented person, which would be the sole proprietorship, the following rules apply. If the form of the signature shows unambiguously that the signature is made on behalf of the represented person who is identified in the instrument, the representative is not liable on the instrument. Do you see that? So by being the representative and signing on behalf of the sole prop, you are not responsible. You couldn't be responsible anyways. So it matches, right? You can't pay anything except in gold and silver coin if you're a white citizen of a state. So, but this all fits into place. You see, I'm trying to fit all the pieces together. Okay. So this fits all the pieces together because you can't pay with gold and silver coins, but they can't really accept anything but legal tender. So the sole prop fixes all of that. The sole prop is going to be the issuer. I'm going to be the representative. The representative is not liable on the instrument. I wouldn't be anyways because I can't even issue the goddamn thing. Now, the question becomes, are state citizens allowed to issue notes and drafts? And the answer is, well, yeah, obviously. Like, we had notes and drafts before all this kind of craziness and goofiness. We had notes and drafts all the way back. I found an 1832 case talking about some of this stuff, right? So the idea that notes and drafts and all this kind of stuff, and the idea that we did generate them, and I generated them, and banks generated them, all the way back, and then you have the Bill of Exchange Act from like England and stuff like that. It's not that you can't do it. It's just, in order to be constitutional, the main currency for all, like, I don't really know how it worked back in the 1800s. Obviously, everyone was exchanging gold and silver coin, but if you wanted to create securities and liens and kind of back-end items, you can obviously do that. I'm sure the banks did that. You can securitize things. You can generate notes. You can generate drafts. You can be the issuer. All the commercial code stuff is really old, actually, and it really hasn't changed at all. That's the thing. Like, even if you look at the final order dismissing my case from Mr. Tavelman in the city of Glendale Round 3, which I'm going to appeals, by the way. I'm working on it now, collecting everything together. You'll see that he even references, I forget what reference it was, but one of the only references that he references in this whole order was a case from like 1855. And that's because a lot of this negotiable instrument stuff really is that old, right? So when the representative, so this fits together, the republic side and the democracy side and the legal money and the lawful money side and the legal tender side, it all fits together here. I'm trying to fit everything together. And by doing it this way, to me, it makes perfect sense. Everything fits together. There is no, like, all the puzzle pieces fall into place and they're flush and they look really nice. And there's no real like jagged edges. There's no like weird anything. So this is what makes sense to me, right? So, we're going to cover this in more detail. So here is the promissory note. Where'd it go? So you have the issuer. The issuer is a sole prop. Here's the date of birth. Now I wanted to talk about this date of birth thing. If you don't, I got this from my certificate of live birth. There's an area on there that says registration date. That's where I got this date from. If you don't have a certificate of live birth, or you don't want to wait for one, what I would do is just do on or about, and then I would just write 2 weeks after you were born. Because I've been thinking about this for years, and I finally think I figured out a way that might work. On or about, and then, just add 2 weeks, 14 days. So if you were born on 12/1/1986, this would say on or about 12/15/1986. And then you can do that, and you can do that immediately, and then just order your certificates of live birth and try to get your hands on those so you can see the actual registration date. And as far as I'm concerned, that's the date of birth of the sole proprietorship. So that's how I would handle that. The citizenship of the sole proprietorship is U.S. citizen and resident of California under the 14th Amendment. Very, very clear. It's clear about the citizenship. It's clear about residency, state residency. And then it's also clear about 14th Amendment, which should be already pretty obvious from what's already said here, but it's just good to be more specific. Type is artificial person, sole proprietorship, right? Representative of issuer, me, my date of birth. Citizenship is white citizen of California under Article 4, Section 2, Clause 1 of the U.S. Constitution, right? So the 2 areas that I gain all of my privileges and immunities is the state constitution of California. Actually, I'm going to add that to this now that I think about it. Let me just add that here. I'm going to add that here. under the California Constitution of 1849 and Article 4. Yeah, that's actually better. I'm still doing a lot of research on this, but basically it's like the way that Article 4, Section 2, Clause 1 operates is it operates under whatever your state's constitution is, and then like your own state's constitution is like the main thing that gives you the privileges and immunities, and then you enjoy the basic aspects of those privileges and immunities in every other state and territory under. So, and again, some of this is not 100% clear for me, so I'm still working on it, but I know it pretty much well enough to understand it. So with a state citizen, your rights are mainly within the Constitution that applies to you within your state. And then outside of your state, like for example, if I'm in Arizona or Florida or New York, at that time while I'm there, I would be operating under Article 4, Section 2, Clause 1 of the U.S. Constitution. And there's been so much confusion. Are you a resident at that point? Even because you're a citizen of California, but you're a resident in New York? Well, no. Because if I'm in New York, let's say for a vacation, I'm not establishing residency because the statutes state that you have to like show or prove that you intend on making it your long-term home. So I'm not establishing residency in New York while I'm there. And you say, well, what are you then? You're not domiciled. Yeah, I don't know the answer to that question, guys. I don't know. I'm still working on all this. I don't know. Still working on it. I'm in the lab every fucking day. Okay. Be nice if somebody else would too. I'm asking too much, I think. I don't know. Inhabitant? I don't know. I would just tell the court if something happened, I'd be like, look, I never established residency. I'm a state citizen of California, and my rights in New York, while I'm in New York as a non-resident, operate under Article 4, Section 2, Clause 1 of the U.S. Constitution, not the 14th Amendment. That's how I would do it. And then I'd be like, I don't know what to call it, Your Honor. I don't know if you want to call it inhabitant, because it wouldn't be a resident, and it wouldn't be a domicile, and I wouldn't be a citizen of New York. So what the fuck would it be called? I have no idea. Guys. I would just say that, though. Oh, what do I say? How do I say it? Just say all that. Your Honor, I'm not a resident of New York. I never have been. I'm not domiciled in New York. I'm not a citizen of New York. I'm a citizen of California, but my privileges and immunities in New York would fall under Article 4, Section 2, Clause 1 of the U.S. Constitution. I don't know what you'd call that. What would you like me to call it for these proceedings? Do you want me to call it foreign inhabitant? Do you want me to just say Californian? A non-resident Californian? I don't know. Whatever you want me to call it, Your Honor, I'm going to call it that because I don't really know what term I should be using to describe that situation. Okay. So this is my main and primary operative. And then federally, with federal questions and stuff like that in federal court or outside of California, it's more along the lines of this. Because you wouldn't go to New York and then cite the California Constitution of 1849 as your rights while you are a whatever in New York. You would cite this as your rights while you are in New York. Not as a resident. I know it's very confusing. There's a reason why this stuff has nobody's ever figured this stuff out, guys. And, I think I've gotten farther than anybody else ever has by far, but I don't have all the answers for you. Okay. Type, natural person. I know previously I've made videos and stuff where I'm not fond of this term, but at this point, I don't really care. Because this here is so unbelievably clear and powerful that I stopped putting without prejudice on things. The UCC doesn't even apply to a white citizen of California. Why would the UCC? Well, we had notes and drafts beforehand, but you can't, like, using notes and drafts as a currency is out of the question with a white citizen of California. So the CCC would only apply to non-currency securities for a white citizen of California, because I wouldn't be able to violate Article 1, Section 10 of the Constitution, right? So, so now that we've got this all figured out, or mostly figured out, this terminology no longer bothers me. I don't really care much about any terminology, to be honest with you. None of it really scares me anymore because I've got the Ninth Amendment, and Hurtado versus California doesn't have any application. So right there, boom, that's it. It's game over, ladies and gentlemen. This whole, like, can't use this word, we got to use this word, oh, be careful. That's all, that era of the sovereignty movement is gone. It's dead. You can say whatever you want. As long as you're clear about this, I mean, you don't even need to use without prejudice, nothing, you know. It's all very irrelevant at this point. We've kind of grown up and out of that as a necessity, right? So natural person, fine. And one of the main cases that kind of got me to kind of back off on not using the term natural person is Paul v. Virginia, a case that I've been putting a lot more attention on recently, right? So in this case, he literally says that a corporation can't be a citizen of a state under Article 4, Section 2, Clause 1, right? It is contended that the statute in this particular was in conflict with that clause of the Constitution which declared that, quote, the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states, end quote. That's Article 4, Section 2, Clause 1. And the clause which declares that Congress shall have power, quote, to regulate commerce with foreign nations and among the several states, end quote. The same grounds are urged in this court for the reversal of the judgment. And then here's the bombshell right here. The answer which readily occurs to the objection founded upon the first clause consists in the fact that corporations are not citizens within its meaning. The term citizens, as they're used, applies only to natural persons. Now I would never say natural persons. Obviously, you know, that's not, they just didn't get it. You know, that's why there's so much confusion on this whole people versus persons thing, because even in the Supreme Court, they didn't really correctly understand what happened between the Dred Scott case and the 14th Amendment. So this really should be natural people, but the term natural person in a singular, I'm not so worried about. It's person. I would never use the word persons, obviously, right? Members of the body politic owing allegiance to the state, not to artificial persons created by the legislature and processing only the attributes which the legislature has provided, right? So this is kind of, you know, I kind of backed off. It seems like I just don't care that much to use this term. I wouldn't say natural persons. I would say natural people, but in the singular, I just don't care that much. Owner of issuer, right? And here's the information. Okay. This note as an original issue is being tendered to the payee at, and then name of payee, and then address that I'll be tendering to. I think registered mail nowadays, they don't give you can't tear off the numbers and take them home. I've heard that reporting some places. You can use certified mail on this, I suppose. Technically, when you send originals of a negotiable instrument, you're supposed to send them registered mail as like added security, but you can use certified mail. I don't really see the downside of that, but whatever you use, like for example, if you use registered, put the number on here. If you use certified, put the number on here. Okay. If you can't get the registered stickers with the numbers, just use certified. It's fine. And then in accordance with the California Commercial Code here after CCC, section 3104, the following promissory note is being issued in accordance with subsection A1, A2, and A3, which we've broken down by section here. So the definition of a negotiable instrument is what we have to achieve in order to have ourselves a negotiable instrument that we can use. It's all defined here, 3-104, A1, A2, and A3. And if you go into my flowcharts, one of the biggest discoveries is this top box, not the very, very top, but the one right below it. A document or instrument only needs the three characteristics found in your state's version of the UCC, section 3104, A1, A2, and A3 in order to classify as a negotiable instrument. Number one, is payable to bearer or order at the time it is issued or first comes into possession of a holder. So we're breaking it down by section. A1. This note is being issued to order and is not blank. The payee is name of payee. So if you're paying, PG&E Energy, that would be PG&E Energy. Whatever the legal name of the payee is what you're going to write there. Section A2. Let me close some of these. I'm a little bit overwhelmed by all of these open. What is this? Oh. Okay. A2 is payable on demand or at a definite time. That one is, this note is payable on demand. You can put payable at a certain time if you want. There's no one stopping you from doing it. And then this is the most important one. And the reason why is because, like I've said before, if an instrument does not state a payee under 3-205, it automatically becomes payable to bearer, even if it doesn't state on the instrument. You can see this on your Federal Reserve notes. Your Federal Reserve notes don't have payable to bearer or to order terminology on them. If you look what's in your wallet, you won't find that terminology. So it automatically defaults to payable to bearer. Federal Reserve note, if you're ever in litigation and opposing counsel brings this point up, you just whip out a Federal Reserve note and throw it on the table and they're cooked. Because you throw it on the table and you say, well, how the fuck does this thing get negotiated? You stupid fucking faggot. I've never seen any bar cards even try to fight this stuff. I mean, I see a little bit of it now when banks are being sued and stuff like that. They're starting to put up a little bit of something, but it's just very pathetic. But I'm just saying, you just throw an FRN on the table and be like, well, how in the hell is this thing negotiated? Then you fucking piece of shit. And the answer is it's negotiated payable to the bearer automatically if it's not. If it doesn't say anything about bearer or order, if it's just got no information whatsoever, it automatically defaults to payable to bearer, right? FRN is the best example of that, right? A blank check is also a great example of that. It's not payable to bearer and it's not payable to order, but the banks treat it as though it's payable to bearer. It's a blank check. So yeah. So number two, payable on demand at a definite time. The bills and stuff typically have a due date, but if it doesn't, that's totally fine. Under 3-108A, you have a default. If it does not state any time of payment and does not say payable on demand, it automatically defaults to payable on demand. So we have a default clause on that one. And then the only one that does not have a default clause is number 3, does not state any other undertaking or instruction by the person promising or ordering payment to do any act in addition to the payment of money. So really all you need is that number 3, but I'm trying to be extra clear. And you can see number 3. This note is unconditional and there are no express conditions to payment, right? Any failure to either process this note as a payment under CCC sections 3602 and 3603 or dishonor it under 3502 will result in litigation being filed under CCC 3303B, which says the following: the drawer or maker of an instrument has a defense if the instrument is issued without consideration, as well as 3603B, which states if tender of payment of an obligation to pay an instrument is, you guys know that one. Okay. The amount on this promissory note is for, let's say you're paying like a phone bill, it would be, 105, whatever, 67. This note is being issued to satisfy the bill date stapled to this note, which is, you could put here like an AT&T phone bill date, 8/25/2026, account number. That might be better, actually, do it that way, right? Probably something like that. That's kind of how I would do it. If I was doing AT&T or, okay, City of Glendale, let's do that, because let's make this more, which is an electric bill. Dated something like that would probably be best. Okay. Please send a receipt of full payment to the representative's address at the top of this note. A durable power of attorney between the representative and issuer is available upon demand. Okay. I'm going to pause the video here for a second. Let me reorganize my thoughts here. Okay, I'm back. Need a little something for my throat. Getting a little bit dry there. So when you build your everything out, you can also use UCC 1-305. Remedies to be liberally administered. The remedies provided by the Uniform Commercial Code must be liberally administered to the end that the aggrieved party may be put in as good a position as if the other party had fully performed, but neither consequential or special damages nor penal damages may be had except as specifically provided in the Uniform Commercial Code or by another rule of law. Any right or obligation declared. When I had my case dismissed with Mr. Tavelman, City of Glendale Round 3, he said that this doesn't mean what I think it means, but he cited no authorities. So I don't. There's some stuff. I mean, look, you guys can talk shit about Mr. Tavelman. I had a long conversation with him. I considered it long. It's probably not very long in the grand scheme of real court procedure. At the end there, and we talked back and forth for a little while. I don't think he's a bad guy, and to tell you the truth, he's talking about some of this stuff where there's not a whole lot of judges that are even willing to talk about a lot of this stuff. So I can't get mad at him. I just don't. If there's no authorities listed, I don't know. I'm going to go to appeals. I'm going to put all that in the appeal. I'll be like, look, he said this, but I don't see any authorities listed here, or I'll have to review it again. If there is something mentioned, I'll have to look and see if I can find anything. But really, the truth is, there's just not a lot of case law on any of this in the last 150, 200 years. So, it's just all goes to appeals. All that's just going to go to appeals. So I don't know. I mean, as far as I can tell, this means what I still think it means, but Mr. Tavelman said that it doesn't. So I just don't know yet. We don't have anything nailed down on this yet. I'm going to keep rolling with this one until I get some real authorities or something to nail this down. I don't know. I don't have enough evidence yet to knock me off this path. I still think this is the same as how I structured it in round 3 and round 5. You know, I don't know what to tell you guys besides that. That's all I can really say on the subject. So that's number. Let me just verify a couple things. Let me just see what we're at here. It's a lot to organize here, guys. So this video is a little more sloppy than usual. I just don't want to wait another month or two to do this video because people are already starting to go crazy. I want to just get this video done, even if it's a little bit rough or on the edges. So I hope you guys are getting something out of it. So issuing a brand new promissory note without using a credit card or other banking instrument. So if you go to court and they're like, you can't just generate your own whatever, then you just reference credit cards. Well, with a credit card, I'm generating my own note. It's the same thing. You're saying generating a note. If you didn't accept me generating my own notes and negotiating to you, then you wouldn't accept a credit card. It's the same thing. A Federal Reserve note is a note that you never issued. You didn't generate it. I never generated the Federal Reserve note. I have nothing to do with the Federal Reserve note. It's Congress's obligation, not even a state citizen's obligation. I can't pay the goddamn thing anyways. It's not in gold and silver coin, you see? So it's just silly. It's very silly, okay? But Federal Reserve notes are issued by United States, which is defined in UCC 9-307. Location of debtor. It's the debtor who's issuing the note. This is the one where you guys see that subsection H. The United States is located in the District of Columbia. And then, for those of you who've been with me for a while, I issued a FOIA request to Washington, D.C. to find out where in the District of Columbia, meaning like coordinates or whatever, and they just flat out refuse to tell me. So we don't know where in the District of Columbia, but this person named United States is somewhere in the District of Columbia. We don't know where. We may never know, but she's somewhere in there. Okay. And you can find that FOIA request. I have on williamslawfirm.com somewhere. I think on the questions and answers page. Well, shit. Did I delete that? Actually? Let me make a note. Hold on I'm going to pause the video for a second. Okay, that was kind of shocking. I think when I did a bunch of edits, I completely gutted the questions and answers page on williamslawfirm.com after the whole practicing law license thing under the Ninth Amendment was realized. And I think there was a link to a FOIA request that I had sent to find out exactly where the United States is in terms of it being located in the District of Columbia in accordance with UCC 9-307H. And I had it on the questions and answers page so you guys could actually use it in your cases. And I think I just somehow spaced out. And here it is. And so what I did was I went ahead and put it on the onestupidfuck.com state citizen resources page. So if you go to the state citizen resources page, it's not going to get lost here. Whereas on the questions and answers page, I just got it. I was so excited when I learned the whole practicing law to license thing, and I just deleted the whole thing. That's crazy. So I moved it here. You're going to scroll down and you'll see here, right here is the link to it. And then now you guys can get this. And it has all the original questions. It has the appeal. It has the appeal terminology. It says everything that I said. And then it has the discussion. And then it has the fact that they're just not going to answer fuck you. And you can use this in your cases to prove that they won't even answer the fucking question, I guess. Okay. Well, that's kind of a cool find. Shit. Sorry about that, guys. Didn't realize I had deleted that. That's fixed. Okay, let me pause the video again and kind of regroup here. Okay, so if you want to, you can if you want to notarize. Originally, I was going to talk about the medallion stamp guarantee, but we actually don't need that. I find out. If you wanted to, you could literally just notarize this. You would just attach like a jurat or whatever. Go to a notary, and they can just attach a jurat to it. Just sign it in front of the notary. And the whole reason for that, if you go to I'm going to take this video and put it on this site here. But you can add this terminology to the note itself. If you do notarize a note, you don't need to do this, by the way. This is just kind of like an added thing, because they don't even talk coherently about any of this. So why you would go the extra mile to make this more coherent when they're just not even going to have any clue what you're talking about anyways. I mean, whatever. But just to make this video a little more evergreen, if they ever do get their head out of their ass entirely, which I know is asking for a lot, you can write here, this note has been notarized to allow the original holder to be the holder in due course of this instrument in accordance with the California Commercial Code 3302. So if we go to the California Commercial Code 3302, I will show you how that works. Originally, I was going to go down the medallion stamp guarantee route, but we don't need that, actually. So holder in due course is if the instrument does not bear such apparent evidence of forgery or alteration, or is not otherwise so irregular or incomplete as to call into question its authenticity. So by notarizing it, you're basically just giving it additional evidence that it's not a forgery or alteration, or is not otherwise irregular. It's just additional verification of the issuer or the representative. So it just allows them to become kind of more of a holder in due course. It allows more protection on the instrument. So if you want to do that, you can do that. And then the other thing I wanted to tell you is, a lot of people are having a hard time where they're sending in things, certified mail or whatever, and then the credit card companies or whoever is pretending as though they never got it. You can use a process server for that, guys. People forget, I thought you only use a process server when you're serving the initial documentation for a lawsuit. No, you can use a process server for anything. And they write right on the affidavit, I delivered the following items. It'll say promissory note, and it'll have cover letter, whatever it is. It's whatever it's named, right? So if you want to, you can use a process server to guarantee that they receive it, guarantee that you have evidence that they've received it above and beyond a certified mail slip, which I think that should be enough, but whatever. Right. So let me just see here. I believe we've covered everything. We've covered everything through here. Okay. And then the fourth style of payment. So that's this one. And you can even say, because it is, right? And the fourth option is one that I figured out while I was doing the research for this flowchart. So if you look at this one's really complex. I don't really understand this one, guys. I'm just going to kind of toss this out there, and you guys can whatever. I'm not going to, this one for sure, I'm not going to even pretend that I understand. Okay. So the drawer is the person ordering payment in a draft, right? So if you look at, right, drawer, City of Glendale issues draft in accordance with, so they're issuing a draft. They're the drawer. They're the one ordering payment, right? If you look at 3-414 subsection A, subsection B. No, subsection B. If an unaccepted draft is dishonored, the drawer is obligated to pay the draft. And this kind of ripped me apart. I was going back and forth with AI, and AI brought this up to me, and I was like, "What in the fuck are you talking about?" So this means if you just tell them to go fuck themselves, they're obligated to pay the draft. Literally. You never accepted it, and if you don't pay it at all, it automatically dishonors. UCC 3-502. I mean, we're having a hard enough time doing the, number 2 and number 3 on this one, simply dishonor the draft. Don't accept it at all. Then force the drawer to pay it in accordance with 3-414B. You are the holder. I mean, I don't know. I literally don't even know how this would work, guys, honestly. Just sue them for failure to perform. I don't know. This one, I just don't know, guys. This one is above my pay grade for sure. So you may want to go back and forth with AI on this to try to learn more. I'm just not sure on this one. I haven't had the inclination to deep dive on this one in particular. Don't really see that I would necessarily need it because 2 and 3 are both really good, and I understand these two really well. This is just a whole nother world of fuckery that I just don't understand yet, but I just wanted to kind of share it with you guys just to show you that there is this actual fourth way of paying, forcing a payment, right? Okay, so that's it. That's all I wanted to show you. I'm not going to get into that anymore. I don't know enough about it to understand it. The way that I wrote in the flowchart is right here. If Brandon Joe Williams rejected, dishonored the draft, and the drawer would actually be liable to pay the instrument in accordance with CCC 3414B. This is exactly why the California Evidence Code 633 and 634 exist. City of Glendale would be legally forced to pay the bill. If they didn't pay it, the holder, Brandon Joe Williams, can actually turn around and sue the drawer for non-payment. This was my understanding of it when I made this flowchart, but I'm not so sure now, because if we look at the definition of acceptance, do I have it on this one? Shoemaker, drawer. A drawee who has accepted a draft. Yeah, I don't know. I don't know, guys. I don't know. That one is just, whew, it's just simply above my pay grade, ladies and gentlemen. I don't know. But I wanted to bring it to your attention that there is definitely something here. There is something in the dirt. And if someone would like to dig, you're going to find, I know it's there. I just don't know how it works exactly. And that's number 4. But this new template is number 3. That's where the new template's located. Okay? You can see in my City of Glendale round 3 case that by doing a small claims case and then doing another case in state court later under an entirely different bill with entirely different circumstances, that's why my case was dismissed, which is complete bullshit. Totally shocking. I had no idea that something so stupid could even happen. Obviously, that's going to be part of my appeal, but just wanted to bring to your attention that you may want to just go straight to state court with a lot of this stuff. I know I've talked a lot about small claims, but I just, you never in a million years would I have expected that they would try to attach the small claims to the state case. And then even when they tried doing that, I laughed. I was like, this is a joke. This is never going to fly. And then sure enough, the court went with it. And I cannot believe it. I literally am just in complete disbelief. So, the whole small claims thing that I've been talking a lot about, I don't know. I don't know if just letting you know that might be some difficulty for you. I imagine I can get it overturned in the appeals. It's just so ridiculous that this even happened. I just can't believe it. I'm still in shock, honestly, how ridiculous it is. So yeah, I wanted to cover that. You may want to just go straight to state and skip small claims. I don't know. I'm still learning, guys. Still learning. Trying to save you guys time. I mean, no one's ever, people file one lawsuit, they lose, or they win a little something, and they just disappear, and they never say anything about it. No one ever knows. Like I think I'm kind of the first guy who tries to publish all this and kind of turn it into like a running record. If I would have found my own work at the beginning when I first started doing all this, it would have saved me years of pain and wasted time. So I'm trying to allow everyone else to start where I'm at, so we can actually get somewhere rather than just everyone starts where I was when I first started